in support of originating summons, the claimant referred this court to the case of Action Alliance and two others versus Independent National Electoral Commission, that is INEC, and reported appeal number CA/168/1068/2019, dated 30th December 2019, as authority for whether the claimant has made out a case for the grant of the relief sought. The claimant did not supply the certified true copy of the judgment since it is unreported. Order 45, Rule 3, Sub Rule 1 of the National Industrial Code of Nigeria Civil Procedural Rules 2017 stipulates that where any unreported judgment is relied upon, the certified true copy shall be submitted along with the written address. And in Major General Kayode Oni, retired, and four others versus Governor of Ekiti State and another, this is what Her Ladyship Augie, JSC, now retired, said, quote, "It is an elementary principle, very elementary, that counsel who wants the court to make use of authorities cited in court must provide the name of parties, the year the case was decided, and where the case is reported. Name of the law report, the year, volume, and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon. C. Chidoka and another versus First City Finance Company Limited and Ugo Ngadi versus FRN. What all of this means is that the claimant does not want this court to use Action Alliance and two others versus INEC. The said case shall accordingly be discountenanced for the purpose of this ruling. I so hope.
As the court pleases.
Why the supporting affidavit in support of the originating summons was sworn to by one Luke Tioyibo, who in paragraph 1 of his affidavit described himself as the operations manager of the claimant. The further and better affidavit in support of claimant's originating summons was sworn to by an unnamed litigation secretary in the law firm of Emakpo, Rikefe and Partners, counsel to the claimant applicant. By this latter averment, it is evidently clear that she or he is not a member of the claimant company. According to paragraphs 2 and 3 of her or his affidavit, the deponent has the consent and authority of the claimant applicant and her or his employer to depose to the further and better affidavit that information deposed to are derived from her or his perusal and familiarity with various documents of the claimant applicant, which came into her or his possession as a litigation secretary, from information derived in the course of interacting and working as the litigation secretary with various staff of the claimant applicant, which she believes to be true. By the averment of the unnamed litigation secretary in paragraph 1, of her or his further and better affidavit, it is evidently clear that she or he is not a staff or member of the claimant company. The deponent is a staff in the chambers of counsel to the claimant. The general tenor of trade union law envisages only officers or members or a member acting for or on behalf of the union. The case of MHWUN versus Minister of Labor and Productivity, citation is in the ruling, for instance, heard that given section 5, subsection 5B of the Trade Unions Act, that is TUA, the registrar refuses to register the union, any official or member of the union may, within the period of 30 days, beginning with the date so specified, appeal to the minister against the refusal. So, in a non-member of a claimant deposing to a further and better affidavit in support of originating summons that activates this suit, can it be said that the said process is valid? I do not think so, especially when the said litigation secretary is unnamed. I acknowledge that Order 3 Rule 17 Sub Rule 1A of the National Industrial Code Civil Procedure Rules 2017 merely provides that an originating summons shall be accompanied by an affidavit setting out the facts relied upon to sufficiently identify the case, the course of action in respect of which the claimant claims relief or remedy. I acknowledge that this provision does not say who should swear to the said affidavit, but it cannot be questioned that it intuits that the claimant himself will depose to the activating affidavit. Claimant is a company and so acts through its officers. I do not think it is right and legal that it will act through an unnamed or a non-officer or employee. The circumstance I am obliged to discontinence the further and better affidavit of the unnamed deponent in support of originating summons. Same is accordingly struck out.
Last call, please.
The case of the claimant is that despite the subsistence of the ruling of the Industrial Arbitration Panel / Tribunal in the dispute between the National Union of Hotels and Personal Services workers, dated 9th November 2021, the defendants have continued to unlawfully interfere with the affairs, operations, and the unionization of the workers of the claimant to the detriment and inconvenience of the claimant. That the defendants have continued to incite and instigate some workers of the claimant to be unruly, disobedient, and irresponsible, and thereby causing loss of man hours and creating a hostile work environment. That the conduct of the defendants is embarrassing, oppressive, and unlawful. Reaction: the defendants maintain that they were never parties to the ruling of the National Industrial Arbitration Panel. I don't know of any National Industrial Tribunal, and have never unlawfully interfered with the affairs, operations, and unionization of the said workers to the detriment and inconvenience of anybody whatsoever. But it is rather the claimant that is interfering with the said workers' choice of the trade union to join by trying to impose the trade union wants on the said workers. But it is not true that the conduct of the defendants is embarrassing, oppressive, and unlawful. That the claimant has not shown good faith, but rather has disobeyed, has displayed bad faith, bias, and is anti-trade union activities against the first defendant union and its members. The notice of award by the IAP in the matter of trade dispute between National Union of Hotels and Personal Services Workers. Management, who is that? Is it Rupert Irikife? Is that Irikife making the noise? Irikife, you are the one making the noise?
My lord, he has been muted. He has been muted. He has now been muted.
If I hear that again, I'm going to cite anybody for contempt of court. You people have to mind it that you are in court. Where was I? The notice of award by the IAP in the matter of trade dispute between National Union of Hotels and Personal Services Workers and the management of Pyramid Company Limited, dated 9th November 2021, made the following findings. There is no dispute. One, there is no dispute between first and second party, as there already exists collective agreement between the parties, and documents attached reveal that second party has since October 2009 till July 2021 paid check-off dues to the first party. Two, there is a subsisting collective agreement signed between the management of Pyramid Company Limited and the executive of the National Union of Hotels and Personal Services Workers on 17th April 2000, and valid for an initial period of 2 years 3. The tribunal also found that a letter of clarification of membership was written to the managing director of Wasam Wasam Urest Nigeria Limited, Nigeria Cleaning Services Limited, and Pyramid Company Nigeria Limited in 2005, advising the companies to accord recognition to the National Union of Hotels and Personal Services Workers as the rightful union to organize their workers. The Industrial Arbitration Panel went on to rule or award as follows. In view of the findings above and in view of the fact that there is no contrary evidence against the position of the partners, the tribunal holds that the National Union of Hotels and Personal Services Workers is the appropriate union to organize the workers of Pyramids Company Nigeria Limited. In paragraph 5 of the notice of award, dated 9th November 2021, the management of Pyramids Company Nigeria Limited or its representative to lodge with the Honorable Minister of Labor and Employment in writing within 7 days from the date of the notice. Within 7 days from the date of the notice, any objection which it may have to the award. In the event of his not receiving any objection from the management or its representative in the manner specified, the Honorable Minister of Labor and Employment shall proceed to confirm the award, which shall then become binding on the management. The records of this court do not indicate that the management of Pyramids Company Nigeria Limited has lodged any notice of objection which it may have to the award. It stands to reason that the second party has no objection to the award by the panel in this matter. In paragraph 6 of the notice of award dated 9th November 2021, it is stated that a similar notice of award had been given to the union. First defendant in this suit, who is first defendant in this suit? With the defendants, especially the first defendant, union, its members working as employees of the claimants in Chevron Nigeria Limited oil and gas operations, activities in Warri Delta State, were never aware of the said purported proceedings and award of the IAP published on 8th November 2021 by the Federal Ministry of Labor and Employment in respect of any purported dispute between the National Union of Hotels and Personal Service Workers and the management of the claimant, that the claimant terminated the employment of 6 workers belonging to the first defendant after long years of service in Chevron, Nigeria, ranging from 17 years to 24 years for no cogent reasons, apart from their activities as members of the first defendant union, that the defendants were never parties to the said ruling of the IAP and have never unlawfully interfered with the affairs, operations, and unionization of the said workers to the detriment and inconvenience of anybody whatsoever. But it is rather the claimant that is interfering with its said workers' choice of the trade union to join by trying to impose the trade union it wants on the said workers. The IAP is first and foremost an arbitral body, not a court of law in the strict sense of the word. As an arbitral body, it lacks the trappings of the court as we know it. The 2 issues this court is asked to resolve, ironically, were not raised before the IAP, as there was no dispute between the National Union of Hotels and Personal Services Workers and the management of Pyramid Company Limited. Firstly, the claimant seeks the court's declaration that by virtue of the valid and subsisting award or ruling of the Industrial Arbitration Panel or Tribunal, published by the Federal Ministry of Labor and Employment on 9th November 2021, which found that the National Union of Hotels and Parastatals and Personal Services Workers is the appropriate trade union to organize the workers of the plaintiff. The defendants have no right to lay claim to the workers of the plaintiffs or to interfere in the exercise of plaintiff's rights as an employee to lawfully discipline or, where necessary, terminate the employment of the workers. To the claimant, the dispute to the claimant, despite existence of Exhibit A, which was triggered by Exhibits B and C, the defendants have carried out the acts complained of in paragraphs 15, 16, 17, and 19 of the affidavit in support of the originating summons. That the issue of the unionization of the workers of the claimant is binding and final and cannot be relitigated again. He cited Usurinde versus Jamogun and Lauren Toba, Oju, and others versus Abdurrahim and others. That defendants' acts of unlawful interference cited in paragraphs 15, 16, 17, and 19 of the affidavit in support of the originating summons are contemptuous of Exhibit A and amounts to self-help, which invariably leads to breakdown of law and order. On whether in the circumstances of this case, the claimant is entitled to the relief sought, claimant submitted that it has made out a case for the grant of the relief sought. Decided Action Alliance and two others versus Independent National Electoral Commission. Unreported appeal number CA/A/1068/2019. To the claimants, the evidence offered in support of the application entitles the claimant to the relief sought. To the defendant, it is the case of the claimant that by the letter dated 2nd August 2021, that's Exhibit B, Federal Ministry of Labor and Employment instructed it to allow the unionization of its workers by the defendants, that the claimant protested against the said instruction via a solicitor's letter dated 3rd August 2021, that's Exhibit C, that the act of not making the defendants, especially the first defendant, parties not notifying them of the purported trade dispute proceedings at the IAP being interested parties was done deliberate and in bad faith, that by the authority of Ghani Tarzan Marine Enterprises Limited versus Caravel Resources and Investment Limited and another. It is submitted that the defendants were necessary parties in the matter at IAP. The defendants urged the court to so hold. On what a party who seeks declaratory relief must show, the Court of Appeal heard in Idigbe versus Barrister Eze Onwuka and others, per Yakubu JCA, that, I'm quoting Justice Yakubu now, quote, indisputably, in an action for declaratory relief, such as the one herein, the appellant was duty-bound to prove his claim on the strength of his own case. This is essentially so, because declaratory reliefs are not granted on a platter of gold. They are only granted cogent evidence, profile, such as the appellant hearing, cited Dumes Nigeria Limited versus Peter Nwakoba and other, cited Colonel Nicholas Yangu, retired, versus Mandilas Limited. This position of the law was re-echoed more recently by the Apex Court in Inek versus Tuma Supra, by His Lordship Fabi JSC of the report that, quote, it has been stated in clear terms that the burden of proof on the plaintiff, that is petitioner, in establishing declaratory reliefs to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on admission by defendant, where the plaintiff fails to establish his entitlement to the declaration by his own evidence. A court does not grant declaration of rights either in default or in admission without taking evidence and being satisfied that the evidence led is credible. Close of quote. Luke, a Tioibo, adult, male, Christian, businessman, Nigerian, and the operations manager of the claimant, deposed in paragraph 7 thus: I know as a fact that the said notice of award was triggered by the agitation of the defendants to unionize the workers of the claimant when they wrongly persuaded the Federal Ministry of Labor and Employment that the first defendant was the appropriate trade union to unionize the workers of the claimant. Close of quote. Now, if as stated by the deponent in paragraph 10, knew that the Honorable Minister of Labor and Productivity has to refer the dispute as to the appropriate trade union to unionize the workers of the claimant to the IAP, when the claimant purported the decision of the Federal Ministry of Labor and Employment directing that the defendants, particularly the first defendant, should unionize the workers of the claimant, the question would arise why all the defendants were not invited to the IAP for the resolution of the dispute. Section 29, sub 2 and 30 of the Arbitration and Conciliation Act, Cap A18, Laws of the Federation of Nigeria 2004, says thus, it's as follows. 29, sub 2. The court may set aside an arbitral award if the party making the application furnishes proof that the award containing decisions on matters which so, however, that if the decision on matters submitted to arbitration can be separated from those not submitted, only that part of the award which contains decisions on matters not submitted may be set aside. 30, sub 1, where an arbitrator has misconducted himself or where the arbitral proceedings or award has been improperly procured, the court may, on the application of a party, set aside the award. 2, an arbitrator who has misconducted himself may, on the application of any party, be removed by the court. In Taylor Woodrow, Nigeria Limited versus Siduch Edna Work GmbH, the Apex Court set out comprehensively what amounts to misconduct by an arbitrator. See also A. Savoya Limited versus Sonubi. Few such acts which are relevant are where the arbitrator fails to comply with the terms express or implied of the arbitration agreement. 2, where the award contains decisions on matters beyond the scope of the reference. 3, and where he fails to decide all the matters that are referred to him. See also Nitel versus Okeke. Still on arbitral award, the Court of Appeal heard in GasLink Nigeria Limited versus Reliance Textile Industries Limited per Ike JSC. Thus, quoting Justice K now of the Court of Appeal, it follows that a party applying to set aside an arbitral award must furnish proof that the award contains decisions on matters which were not submitted to the arbitration, or that the arbitrator misconducted himself in that he failed to comply with terms express or implied of the arbitration agreement, that the award went beyond the scope of the reference, that the arbitrators breached the rules of natural justice and overheard one party but refused to hear the other party, and proceeded to decide the dispute on a point not put by the parties, showing the award is not good on the face, or is afflicted with an error of law on the face of the award, or was improperly procured. Vide Nitel Limited versus Okeke Supra, pages 473, 474, and 477, close of quote. My take on the declaratory relief sought by the claimants, firstly, is that it is not within the competence of the claimant to determine that the defendants wrongly persuaded the Federal Ministry of Labor and Employment to take any decision or action it took. If there was no dispute between the first and second party, as there already exists a collective agreement between the parties, it stands to reason that the arbitrator misconducted himself in making the award it made, and in the process, the arbitrator misconducted himself. It is also my determination that the arbitrator breached the rules of natural justice by not factoring the first defendant in the arbitration process. The claimant accordingly failed to hold. The injunctive reliefs and general damages sought are accordingly not grantable, and I so hold. On the whole, see no merit whatsoever in the claimant's case. It fails, and so is hereby dismissed. The IAP award of National Union of Hotels and Personal Services Workers as the appropriate union to organize the workers of Pyramid Company Nigeria Limited is hereby set aside. Judgment is entered accordingly, and I make no order.
My Lord, we are grateful.
My Lord, we are also grateful. My Lord,
I don't want anybody, wait. I don't want people to tell me they are grateful. I'm not doing anybody any favor.
My
I'm
Lord,
delivering justice.
my Lord, we are just grateful for the industry exercise.
Wait, I'm delivering
Lord,
justice. Wait. I'm delivering justice as I see it.
As
That is my duty.
my Lord, there's no appearance for the defendant. So
My Lord, I'm appearing. Sorry, you can't say that. I've been trying to appear, but my network was very bad, and I can appear now with the leave of the court. My Lord, with your leave, my humble appearance for the defendant. Most grateful, my Lord.
What did you say your name was?
My Lord, O.A. Appearing for all the defendants. I apologize for appearing after the judgment.
Give me the. You? That's number 2. Yes. The second, Idigbe, God's Nigerian Egypt Company Limited, and another. Can I have appearances in this matter?
So sorry, my lord. So sorry, my lord. Is it number 2 on the court list?
I called the parties. If you are representing any of them, and now for appearance.
Sorry, my lord. I didn't hear it, my lord. Sorry, it's network issues. So sorry, my lord.
You know the name of the parties you are representing.
I didn't hear the name of the party.
Whether it's number 2 or number 10. I called for is it number 1? Number 2. Mr. NICM/Enugu/154/2013, Mr. Igokoja God's Power Ogenejabo versus Nigerian Egypt Company Limited.
With the greatest humility, my lord, sir.
And another. Yes.
Sir.
I'm hearing you.
My lord, I am S. Ayo Ohiria. Defendant, sir.
You are who?
E.S. Ayo Ohiria. O-Y-O, my lord. Ohiria. O-K. I.
Why didn't we have name?
For the second defendant, my lord.
You say your name is Ayo who?
Yes, my lord. Ayo. Ayo is A-Y-O. Ohiria is O-K-H-I-R-O-I-A. The compound name, my lord. E.S. Ayo Ohiria, my lord. For the second defendant.
Yes.
For the second defendant, my lord.
Yes, who else is there? In number 2? Fine. Nobody for the claimant?
My lord, I can see the claimant's name being online, but I don't know whether he's not hearing us. I can see a Simeon Anthony online, but I don't know why.
Well, there are 2 other cases. They may be in another matter. I think we're loud enough for anybody who has hooked properly to know where we are now. Number 2. And I call the names.
Stop, please, sir.
I proceed with the judgment. I have carefully considered the processes, the issues raised, and the submissions of parties. It should, however, be noted that contract of employment may be in any form, and it may be inferred from the contract of the parties. It can be shown that such contract was intended, although not expressed. See Johnson and others versus Moby Producing Nigeria Unlimited and others. The citation is in the judgment. In Longe versus FBN PLC, the Supreme Court per Adekoye JFC heard, contract of employment contains the terms and conditions that will regulate the employment relationship, such as terms on determination, notice, wages, wage benefits are usually contained in the expressed contract of service or implied into it. Employment generally affects the terms of the contract of employment. There are 3 categories of contracts of employment as follows: purely master and servant relationship, servants who hold their office at the pleasure of the employer. See employment with statutory flavor. The master and servant relationship, the master has an unfettered right to terminate the employment, comply with the procedure stipulated in their contract. In a contract with statutory flavor, the employment is protected by statute. In the event of termination of employment with statutory flavor, strict adherence must be had to the statute creating the employment. The statutory provisions cannot be waived. Now the question arises as who is an employer? The Oxford Advanced Learners Dictionary The Oxford Advantage 376 defines an employee as a person who is paid to work. Diamond Bank versus Unaka and others, a contract employment was defined in the business dictionary as an employee who works under a contract for an employer. One for specific job at a specific rate and who does not become a regular addition to the staff and is not considered a permanent employee. Having determined who an employee is, the pertinent question to determine, therefore, is, was the claimant an employee of the first and second defendant? The answer is in the affirmative. what kind of relationship existed between the parties. The evidence before the court is clear. The statement of claim of the claimant, particularly paragraphs 4, 5, 6, 7, and 8, as well as paragraph 7 of the first defendant's statement of defense, and paragraph 7 of second defendant's statement of claim, all points irrevocably that the claimant worked for the first defendants at the Kwale Opai gas plant in Kwale, Delta State. The averments in the above mentioned paragraphs were corroborated in evidence during cross-examination of the claimant on 30th of January 2019 by the first defendant, when he stated thus: I deny the suggestion of counsel that the second defendant redeployed me in 2009. The first defendant redeployed me as a labor contract staff, as a medical department of the first defendant, close of quote. When cross-examined by the second defendant, he further stated that, quote, the letter I referred to in paragraph 4 of my deposition was not issued to me by the second defendant. It was the first defendant that issued the letter dated 23rd March 2009 to me, and it was based on the said letter I was moved to the first defendant in 2009. Furthermore, these pieces of evidence were likewise corroborated by the defendant's respective witnesses. Paragraph 5 of the statement of defense of the first defendant, it avers thus, quote, the first defendant, in further answer to paragraph 4 of the amended statement of claim, state that as it is practice of oil companies, if there is a demand of personnel in an area of operation and the request for assistance is forwarded to any of its servicing companies, how and who they supply is purely their prerogative. Once the requested personnel is supplied, the company decides which operation he is most needed and he is deployed to such department, close of quote. Collaborating the averments in paragraph 5 of the first defendant's statement of defense above, DW1 on 7th October 2021, when cross-examined, stated thus, quote, I am a contract staff. A labor contract staff is employed when there is need for a labor personnel to do a particular job. I am one of such for the transport sector of the first defendant. I had to apply through a company called Florima Nigeria Limited, close of quote. DW1 denied knowledge of Exhibit CW1, stating that first defendant's contracts are not done on the basis of letters. The first defendant during the course of trial contended that the claimant was still at all material time the staff of the second defendant, hinging on the contract between the first and second defendants, which is specifically for the second defendant to supply drivers and vehicle for the first defendant for the period of the existence of their contract, which fact was admitted to by the second defendant in paragraph 7F of the second defendant's statement of defense. However, on cross-examination of the second defendant's witness, that is DW1, by the second defendant on 22nd November 2021, he said thus: first defendant retained the services of the second defendant in the provision of vehicles for the operation of the first defendant. These vehicles are supplied by the second defendant. It is assumed they are owned by the second defendant. Personnel of the first defendant's company who are qualified according to safety standards of first defendant are insured to drive those vehicles within the framework of the arrangement between the first and second defendants. Claimant drove ambulance belonging to first defendant. The purport of analyzing this piece of evidence is hinged on the last line of the above paragraph. Thus, I am made to understand from the evidence first defendant drives the first defendant's vehicles, while the service workers of the second defendant drive the second defendant's vehicles. What then can be said of the claimant who the first defendant claims were staff of the second defendant, but was second defendant's witness DW1 during cross-examination on 25th May 2022 further buttressed this piece of evidence when he stated as follows. What it means is that the second defendant will supply a vehicle and supply a driver that will drive the said vehicle for first defendant. Second defendant has the vehicle and a driver. Invariably, the claimant who was with the first defendant from February to August was not driving the vehicles of the second defendant, but the first defendant. But according to the first defendant, exhibits CW1 to CW5 does not confer upon the claimant an employee of the first defendant. Thus, on how to determine the intention of parties to a contract per Onyemena, JCA, in March, SA, and another, versus Shield Energy Limited and another, the court held that, quote, in ascertaining the intentions of parties to a contract, regard must be had to the terms of the contract, the conduct of the parties, and the circumstances of the case. Emphasis is mine. Although the first defendant argued that labor/service contracts are not done on the basis of letters, that is exhibit CW1 to CW5, conduct of the parties vis-a-vis those exhibits in order to give meaning vis-a-vis those exhibits in order to give meaning to the relationship that existed between the parties. The first defendant admitted that the claimant was posted to the first defendant on a relief duty as a driver by the second defendant, but still remained a staff of the second defendant. It's important to state at this point that the said posting, first defendant also denied ever existed through DW2, that is Mr. Abo Ade, when in paragraph 5 of his witness deposition on oath, he averred thus, that a thorough investigation done in-house to determine the origin of the letter of consent of 23rd March 2009 revealed that the said letter was forged and did not emanate from NAOC head office or the Kwale gas plant. The letter does not have the required authorization to write such letter. On cross-examination, this said witness denied knowledge of the exhibits CW1 to CW5, stating they never emanated from the first defendant, who also denied ever knowing the claimant drove for the first defendant from the period of February to August. It's just getting dark. It is tried principle of law. Pass this side. Don't put it in my pass that side. It is tried principle of our jurisprudence that a party cannot approbate and reprobate at the same time. A party must be consistent in the presentation of its case at all material times. See that admonishment in the case of Ude versus Nwara. The citation is in the judgment. The first defendant stated that a service staff cannot be redeployed to a labor staff by mere letters, but failed to furnish the court with documentary evidence on how a staff can be redeployed to a labor staff. This is so because the court cannot speculate how a worker becomes a labor personnel of the first defendant without the courts, being a court of law, cannot speculate on these facts. See Kenta Best Nigeria Limited versus AG River State. Citation is in the judgment. All the first defendant has done in this case is to leave the court on speculation on how a service personnel becomes a labor contractor of the first defendant. The first defendant further alleged that Exhibit CW1 was forged. It is trite that where issue of forgery is raised, it must be proved by the party alleging forgery. See Okpalangwa versus FRN, where it was heard that before an allegation of forgery can be said to be established, the original documents and the forged ones must be tendered in evidence. Exhibit CW1 was signed by one Nwogu, CE, gas plant superintendent, Kwale, Exhibit CW2 was addressed to the gas plant superintendent, who signed Exhibit CW1. Argument of the first defendant that Exhibit CW1, CW3, and CW4 were not written by Ajib letterhead, but rather in the letterhead of the Quality/Opie gas plant is unfounded. Letters preferred I have seen the said letters referred to above as Exhibit CW1, CW2, and CW4. I do not see a letterhead of Quality/Opie gas plant on them. The first defendant did not furnish any document from the first defendant to enable the court compare and draw conclusion on whether CW1 and the other documents emanated from the first defendant. The only thing placed before the court is the written statement on oath of the first defendant's witness in the absence of any evidence, arguments, or submission of the first defendant on that regard. Is unfounded and are hereby discountenanced, and I so hold. Thus, a careful examination of Exhibit CW1, CW3, and CW4 would clearly define the intention of the parties in this case as per their work relationship. In Exhibit CW3, the Erie Field Supervisor, that is Victor UC, wrote a letter to one Christian Okitiakwa and copied Joshua Osakwe with the subject, Relief Ambulance Driver's Salary. The body of the letter indicates to me that the sender is inquiring why the claimant has not been paid his salary since February to August 2009. This letter was not sent to the second defendant or any of its staff, but to the staff of the first defendant. CW4, on the other hand, explains further that Exhibit CW1 explains Exhibit CW1 more clearly. The first paragraph of Exhibit CW4 provides as follows. In view of the outcome of the recent negotiation/agreement between NAOC management and labor contract workers, which brought about the issue of 1-to-1 work ratio, while the purport and intention of Exhibit CW1 may not have conveyed clearly the intention of the writer, when it stated the management of Kwale has decided to redeploy Mr. Ihiogboa, a God's power, your employee under service contract to labor contract to meet up operations in our medical department, close of quote. From my observation, therefore, the bone of contention is that the statement contained in Exhibit CW1, redeploy Mr. Igogboja or God's power, your employee under service contract to labor contract, and that is why in Exhibit CW3 and CW4, it never stated in them that the claimant is a staff of the first defendant or a labor personnel. In fact, in Exhibit CW4, claimant was still referred to as a driver with Troika Nigeria Limited. Second defendant, the second defendant via Exhibit CW2 asked that the gas plant superintendent put a contract in place of the claimant, but that was never done. The letter was also never replied to. This fact was admitted to by the claimant and the defendant in this case. Thus, the court cannot read meaning or give purport to a contract what the parties never intended. It would be a different case if the parties are ad idem to the employment of the claimant. Then the court can draw an inference of the intention of the parties. That is not the case in the instant suit. There is no contract of employment or an employment letter which the court can look into to decipher the intention of the parties. The most fundamental term of the relationship between the claimant and the first defendant was left undecided via Exhibit CW2. That would have determined whether the claimant was being employed by the defendants as a labor contract personnel. Thus, arguments of the claimant that Exhibit CW1 to CW5 made him a labor contractor of the first defendant is unfounded, and I so hold. However, there is evidence that the claimant worked for the period of February to August 2009 in the establishment of the first defendant. As seen via Exhibit CW5. It is also gathered from the evidence of parties and their witnesses during cross-examination that the claimant drove the ambulances belonging to the first defendant for those periods, which is not in the nature of contract between the first and second defendant. Claimant was driving the vehicle of the first defendant, thereby making the second defendant into believing that of a truth, the claimant is now under the employment of the first defendant. This confusion would have been settled if the correspondence of Exhibit CW1 was explained to the claimant and the second defendant, if Exhibit CW2 was replied to. It is important to note that each case must be considered with its own peculiar facts and circumstances. Having said that it is against the principles of labor for someone to work without pay, the carelessness of the first defendant cannot make the claimant suffer or make the second defendant liable when by the actions of the first defendant, the claimant and second defendant were made to believe an employment relationship existed between the claimant and the first defendant. The law is settled that where a plaintiff can prove the rendering of service under an enforceable contract. Under an enforceable contract, contract is admissible as evidence of the value of the services rendered, and he may recover on a quantum merit basis. Put differently, where work is done or services are rendered by the plaintiff at the request of the defendant, and of which the defendant has had the benefit, plaintiff can recover the value of the work done or services rendered on a quantum merit. See Alfutrin Limited versus the AG of the Federation and another. Citation is in the judgment. It's on the above reason that the claimant's relief we fail. There was never a redeployment by the first defendant in the first place. More so, specific performance is not ordered in the case of master and servant relationship. See Balogun versus University of Abuja. The citation is in the judgment. The evidence before the court is not sufficient enough to grant such relief A. Relief B borders on reinstatement. Position of the law on reinstatement, as the second defendant rightly submitted, is that reinstatement is only applicable when the employee is a public officer whose contract has statutory flavor. See Olatu Bosun versus NISA. Where the contract is a mere master and servant, the court cannot order a reinstatement. Claimant submitted in his final written address that the relationship between the defendants and the claimant are contract of service, as the first defendant prescribed. When the claimant resumes duty and also provides operation transport duty roster for claimant's punctuality. This piece of evidence is suggestive that the claimant was subjected to the dictates of the first defendant for the periods of February to August 2009. Purely a master and servant relationship. And in that case, first defendant or the second defendant can hire and fire at will. Plus The court Relief C is for monetary claims, and so the claims for special damages. And by the decisions of NNPC versus Cliffco Nigeria Limited and 7-Up Bottling Company PLC versus Augustus, special damages must be specifically pleaded, particularized, and specially proved with credible and compelling evidence to the satisfaction of the court. The unreported suit number NICN/LA/18/2013, delivered on 4th June 2018, was heard as follows. In labor relations, the burden is on the claimant who claims monetary sums to prove not only the entitlement to the sums, but how he or she came by the quantum of the sum. And proof of entitlement is only by reference to the instrument or document that grants it, not the oral testimony of the claimant, except if corroborated by some other credible evidence. Claimant is seeking the salaries and entitlements owed to him by the first defendant from February 2009, when the defendant promoted the claimant to labor contract personnel, to when the defendants understand this. To when the defendant's file refused and neglected to pay the claimant and all the claimant's said salary, salaries and entitlements / allowances till when the judgment, till when judgment is delivered in this case. Claimant relied on the collective agreement between NAOC, Labor Contractors Association, and the National Union of Petroleum Natural Gas Workers, that is NUPENG, as well as the summary of economic items as agreed during the full negotiations between NALACA and NUPENG and NAOC, labor contracts, worker branch of the NUPENG, Exhibit CW 16, 17, and 18. Nevertheless, in Exhibit CW 16, an employer was defined to be NAOC Contractors Association, while employees means NAOC Labor Contract Workers branch for NUPEN. From the definitions proffered above, it is certain that the claimant is not privy to this agreement, as he is neither an employer nor employee as envisaged from the said Exhibit CW 16. Thus, what is it? I can't see. Thus, as a general rule, the doctrine of privity of contract is that a contract cannot confer or impose obligation arising under it on any person except the parties to it. See Forbson Fitness Center and another versus Kappa Holdings, 2014. The citation is in the judgment. All the entitlements and allowances, benefits, as enumerated in these agreements exhibited by the claimant can only be enforceable against the parties to it. Claimant in this case is not an NAOC labor contract worker, and as such cannot place reliance on those exhibits. And I so hold. The argument of the claimant that having been redeployed by the defendants as the labor contract staff, he became a member of the National Union of Petroleum and Natural Gas Workers, and also in the category of skilled group, for which skilled group C, for which the salary of the claimant is being determined, is unfounded, and I so hold. Be that as it may, every worker is entitled to wages, and in this case, the claimant is entitled to be paid by the first defendant for the period he worked with the Kwale gas plant and at the Erie flow station. And to determine what quantum the claimant is entitled to, in the absence of any other document showing what the claimant's salary was, what ordinarily is paid drivers of the first defendant whom the claimant worked with would be best described as what is to be paid to the claimant. This is because Exhibit CW6 showed that the claimant was working on shifts with other employees of the first defendant, who are regarded as Group C skilled group under the NAOC labor contract workers. In that case, claimant is entitled to 127,391 naira basic salary on a monthly basis from February to August 2009, totaling the sum of 891,737 naira. That would only be just and fair to the claimant, and coupled with the fact that Office of Special Assistant Security to His Excellency, the Governor's Office, Asaba, intervened on this issue via Exhibit CW14 and pleaded with the first defendant to pay the claimant his salary from February 2009 to August 2009. Claimant cannot go home unpaid, having worked. What the claimant cannot ask for is entitlement, benefits, and salaries for the period he did not work, for that would only be possible if he were employed by the first defendant and his employment wrongly terminated by the first defendant. The instant case, his employment can best be described as a contract employee, as earlier defined in this judgment. On that basis, the above relief C only succeeds in part. Relief D is for general damages of 10 million naira. General damages are not granted as a right. Claimant must specifically prove them. To be entitled. There is nothing else to support his claim. Relief D cannot accordingly be granted. It fails and is hereby dismissed. On the whole, and for avoidance of doubt, claimant's case succeeds in part, and only in terms of the following orders. 1, the first defendant shall pay to the claimant the sum of 891,737 naira. Being salaries calculated from February to August 2009. Judgment is entered accordingly. I make no order as to cost.
As the court pleases. Much obliged, my lord. Lord, we are grateful, sir.
Who announced the appearance?
Hello, second defendant. Second defendant, my lord.
Okay. What's your name again?
E.S. Ayo Ohiria.
Oh, okay. I have recorded that already.
Yes, my lord.
Good.
Most grateful, my lord.
Right. What is today's date?
29.
Hmm?
9.
That other file I treated, I didn't treat the date. Twenty.
29. 9.
Which one is this one?
Number.
Hmm?
Number 3.
Which one? This is the judgment. Okay, number 3 on the course list is NICN Asaba /13/2020, Mrs. Omawumi Elameri Tomara, and the executive chairman, Post-Primary Education Board, Delta State, and 5 others. Can I have appearances? In number 3?
May it please this honorable court.
Yes.
UP Okolotu, Senior State Counsel, Delta State Ministry of Justice. My humble appearance is for the 1st to 5th defendant.
You are appearing for who? 1st to 5th?
Yes, my lord, 1st to 5th
Okolotu, let me hear you
defendant.
well. You are appearing for?
I'm appearing for the 1st to 5th defendant.
I got that.
Okay. Most grateful,
Yes.
my lord.
Yes, you're welcome. Who else? Anybody? Okay. This is my judgment. I've carefully considered the facts as contained in the pleadings of the parties, issues raised in this evidence before the court. From the release of the claimant, it is clear that the main claim of the claimant is basically the suspension of the claimant's salary by the first defendant. The 1st to 5th defendants did not deny that the claimant's salary was suspended since October 2019, but rather that same was an administrative measure taken by the first defendant, which this court cannot interfere with. Backing up their actions, they referred the court to the following rules of the Delta State Public Service Rules 2001. For the sake of clarity, I shall reproduce them. A, Rule 04405. Suspension should not be used as a synonym for interdiction. It shall apply where a prima facie case, the nature of which is serious, has been established against an officer, and it is considered necessary in the public interest that he should forthwith be prohibited from carrying out his duties. Pending investigation into the misconduct, the Civil Service Commission or the Permanent Secretary, Head of Extra Ministerial Department, if within his delegated powers, shall forthwith suspend him from the exercise of the powers and functions of his office and from the enjoyment of his salary. B, Rule 04307. An officer who is paid on other than an hourly basis for reward, unless he has previously obtained the permission of the Permanent Secretary, Directorate of Establishments and Pensions, which only be given if such engagement is not likely to interfere with the efficient performance of his duties. C, Rule 04312. An officer shall not lend money at interest, whether in mortgage or otherwise. The claimant, in proving her claim, also drew the attention of the court to some provisions of the said Delta State Public Procedure Rules, which I shall likewise reproduce hereunder as follows. D, Rule 030101. It shall be the duty of every officer to acquaint himself/herself with the disciplinary rules and any other regulations in force. Delta State Civil Service Commission had delegated full disciplinary power to permanent secretaries and head of extra ministerial offices in respect of officers on salary grade level 13 and below, with the exceptions of power of dismissal, which has been delegated only from grade level 06 and below. This chapter shall be read in conjunction with guidelines for appointments, promotion, and discipline, published by the Delta State Civil Service Commission. E, Rule 030304. A, it shall be the duty of every officer to report any case of misconduct that comes to his or her notice to an officer superior to the officer involved. B, where an officer misconduct is brought to the notice of his or her superior officer, it shall be the duty of the superior officer to report it to the permanent secretary, head of extra ministerial office, without delay. If he or she considers it necessary that the officer should be interdicted, such recommendation shall be made in the report. The first to fifth defendants relied heavily on the provision of Rule 04405 of the Delta State Public Service Rules 2001 in support of their case. And that is to say that the claimant was always absent from work and not performing her duties as a teacher. Paragraph 6, sub 8 and 9 of their statement of defense, they averred that the letter of 11th April 2019 and 3rd September 2019 was not delivered to the claimant because of her well-documented absenteeism from work. To the first to fifth defendants, a prima facie case of absenteeism and financial embarrassment was established against the claimant. hence the justification for the suspension of the salary of the claimant based on the principle of no work, no pay. The first to fifth defendants relied on exhibits DW1/2 time and attendance data sheet of Idigbe Grammar School from Hakabela, a consultancy firm engaged by the Delta State government to monitor the work attendance of its staff in the state. In rebuttal to this, the claimant submitted that Exhibit DW1/2 is computer-generated evidence, and Section 84 of the Evidence Act was not complied with, that it is only an officer from Hakabela that can tender Exhibit DW1/2 and not DW1, Caroline Odieti, that this court should discountenance evidence given by the said witness as same amounts to hearsay. The first, open this. Okay. Close this. That the evidence of DW1 falls under the exception to the hearsay rule, coupled with the fact that those information were gotten in the discharge of her official duty as the Chief Education Officer in charge of discipline in the first defendant. So I earlier pointed out, the first to fifth defendants contended that suspension of the claimant's salary was not wrongful, because there exists prima facie case against the claimant. First to fifth defendants went further to define prima facie case according to the case of Jiboye and another versus the state. They placed reliance on rules 04405 of the Delta State Public Service Rules 2001, which I have earlier reproduced. From the above rule, suspension and interdiction were treated separately. Pleadings of the parties in this case, as well as their evidence before this court, did not suggest that the claimant was at any time suspended from duty, but rather that her salary was suspended. In fact, the first to fifth defendants submitted unequivocally that the suspension of salary did not bring the employment of the claimant to an end, but only a temporary measure pending investigation of the allegations against the claimant. Furthermore, the first to fifth defendants stated countless of times in their statement of defense and evidence before the court that the suspension of the claimant was as a result of the absenteeism of the claimant from duty. In other words, the first defendant's justification for suspending the salary of the claimant was as a result of her being absent from duty and not based on the allegation of the sixth defendant as the claimant alleged. On the issue of the petition by the sixth defendant, the claimant submitted that the first to fifth defendants have no powers to investigate on the issue, allegation of the six defendants, that only a court of competent jurisdiction can adjudicate upon such issue. At this point, therefore, it is important to consider the allegations by the sixth defendant and whether same constitutes a misconduct or serious misconduct according to the Delta State Public Service Rules. According to Rule 3030301, misconduct is defined as a specific act of wrongdoing or improper behavior which is inimical to the image of the service and which can be investigated and proved. It can also lead to termination and retirement. It includes A, scandalous conduct, such as immoral behavior, unruly behavior, drunkenness, foul languages, assault, battery, refusal to proceed on transfer or to accept posting, habitual lateness to work, deliberate delay in treating official documents, failure to keep records, unauthorized removal of public records, dishonesty, negligence, membership of courts, sleeping on duty, improper dressing while on duty, hawking merchandise within office premises, refusal to take or carry out lawful instruction from superior officers, malingering, insubordination, discourteous behavior to the public. Rule 04401, on the other hand, defines serious misconduct as a specific act of very serious wrongdoing and improper behavior which can be investigated and proved. The first to fifth defendants alleged that the allegation of the sixth defendant is a serious misconduct. Hence, letter date September 2021, that is the query, was written to the claimant to answer to them. The claimant, in response to the letter of 11th April 2021, wrote Exhibit CW2. Having analyzed Rule 04401, dealing with serious misconduct, and assuming that it was based on the allegation made by the sixth defendant that the first defendant suspended the salary of the claimant. The question, therefore, is what other actions were taken by the first defendant as regards the letter by the sixth defendant aside letters of 11th April 2021 and 3rd September 2021. The provision of Rule 04401 emphasized that such a misconduct must be investigated and proved. For the provision of Rule 04405 to be applicable, an employee in question must be suspended from work, and suspension of the salary must follow suit by reason of the word "and" used in that provision. The first to fifth defendants cannot place reliance on that provision, since in the instant case, the claimant was never suspended. Rule 04401 provides that a serious misconduct must be investigated and proved. Absenteeism is thus not listed under Rule 030301 of the Delta State Public Service Financial Embarrassment contained under Section 030301. Thus, both Rules 030301 and 04401 provide that such a misconduct must be investigated and proved. Absenteeism and money laundering should ordinarily fall under serious misconduct by virtue of Rule 04401, but to succeed under those rules, the conduct must be proved to have been investigated and proved. And after investigation is concluded and a prima facie case is found, Rule 04405 of the Delta State Public Service Rule on suspension and interdiction can apply by the appropriate authority. First to fifth defendants stated countlessly that suspension of the claimant's salary was done before investigation. See paragraph 9, sub 2 of the first to fifth defendant statement of defense. Again, the first to fifth defendants did not file a counterclaim in this suit as regards financial embarrassment and the other allegations levied on the claimant. The court can only look at the claims of the claimant and resolve the issues emanating from the claimant's release. Exhibit DW1/1 also shows that the first defendant, for whatever reasons, turned a blind eye on the money lending business of the first claimant. Argument of the claimant that the first to fifth defendants have no power to investigate on the letter written by the sixth defendant is misconceived, and I so hold. Rule 04401 Delta State Public Service Commission Rule gives the first defendant power to investigate and prove a misconduct. But however, since the allegation involves money which the claimant is said to be owing another, the first defendant has no power to decide one way or the other, but to advise parties to go to court. Nevertheless, the first to fifth defendants stated that the suspensions of the salary of the claimant was due to absenteeism, and that would therefore be the issue to be considered in this judgment. Put differently, was the issue of absenteeism proved by the first to fifth defendants? In Nimfel von Zendash and others versus Mr. Clapperton, that it is a party who are certain of proof. Burden of proof, where a negative assertion forms an essential part of the case. The first to fifth defendants alleged that the claimant was habitually absent from school. During cross-examination of DW1, that is the defense witness, Caroline Dieter, stated that she has never been to Idigbe, know that the claimant is always absent from school through the information supplied by Hakebela Register and through the information supplied to her by the fifth defendant. DW1's testimony that she has not been to the said school means that she cannot tell for a certain if the claimant was present or absent for those periods as alleged. Claimant submitted that this piece of evidence by DW1 is hearsay and urged the court to discountenance them. However, the first to fifth defendants contended However, the first to fifth defendants contended that the evidence falls under the exception to hearsay